Last case on the docket this morning is Land Trust versus Nation Star Mortgage.
Good morning to the court. My name is Gregory Mauser. I represent Land Trust Services, and I would like to reserve 5 minutes, if I may, for any
When the
rebuttal.
yellow light goes on, you'll be into your rebuttal time.
All right, thank you. If it please the court, this action is before you based upon an appeal from a final summary judgment entered in a foreclosure matter against my client. This summary judgment was entered despite the fact that there is a dispute of material fact regarding standing, and those disputes are, in the complaint, it's alleged that plaintiff was the owner and holder, and also that, in the complaint they allege that they were the owner and the holder of the notes, and that the note was based on a certificate of note possession, was in the possession of their attorney at the time suit was filed. They supplied documents in discovery that were before the court that showed that the note was actually, according to their own records, in a vault in Iron Mountain, Colorado, and we don't know on whose behalf it was held there, which is going to come up in a second. Also before the court was a letter directed to my client saying Nation Star is not the owner and holder, it's actually Freddie Mac, and Nation Star is just a servicer. It's not what they allege in their complaint. None of that would be too shattering, except for the fact that in their complaint and in their records, they are attempting to enforce a note that is different than the one that is attached to the complaint. The note attached to the complaint has an interest rate of 6.25% or something like that, and has a monthly payment amount. All of the records they attached to their motion for summary judgment show that they are attempting to enforce a note that has a 3.25% interest rate and a different payment amount. So there's...
Ask you this.
Yes, sir.
This case went to trial instead of summary judgment, and you had a note and a mortgage that came in evidence, and the note says 6% or whatever.
Yes, sir.
And there's no dispute the payments were made up to a certain date, and then after that there were no payments made. If the records indicate a lesser amount or a lesser percentage or whatever, would they still be entitled to a judgment?
No, sir. Not even close. They have to prove the elements of their complaint. They attached a note to their complaint, and they have to show that that is the note that they are attempting to enforce. What this is a clear indication of is that there's some modification that has not been recorded, because we checked the record. It's not been recorded, wasn't attached to the complaint, shows a different rate, and if a note is not recorded, and if it was for a greater amount, we don't even know because we've never seen it, but if a mod was recorded, unless it was recorded, it couldn't even be enforced.
So there's about 2 years between the time the complaint was filed and the time of the summary judgment. Mm-hmm. Was there any, a lot of time for discovery, et cetera, was there any summary judgment evidence that there was in fact a modification?
No, except for the dispute, and I use that as an educated guess. That's the only way that I could think of that they would be servicing a loan that has a different interest rate and a different monthly payment amount than the note that they attached to their complaint. Bottom line is there's no way to reconcile it, and they did not attempt to do that at summary judgment.
Well, if you had a note and, set forth, what the amount of the note was, what the interest rate was, and the length of the mortgage, if you would, and how long the note was to be paid for, and you knew that payments stopped on a certain date and payments have been made up till that date, do you even need the payment history? Or can a judge just figure out, okay, at this time,
Right.
With an amortization schedule, this is how much is owed, and
If a judge on summary judgment is allowed to figure out questions of fact,
I'm not saying,
I would say that's
questions
what
of fact. I'm
that's
saying
what they'd have to
if
do.
you had a note and it says what the rate is and what the amount is and the length of time to pay it is, and you know that there were payments up to this date, no payments after that,
right.
I mean, then it's just, pulling out an amortization schedule and plugging in the amount.
I would agree with you, except there's an extra wrinkle in this, and that is, I moved to strike the affidavit of the individual who put forth those records.
Did you ever get a ruling on that?
No, I didn't, but I never got a ruling on anything, and I'll get to that in a second. It was part of my response to the motion for summary judgment. Right in there, first part is motion to strike affidavit, and the motion to strike the affidavit is predicated on the fact that the records utilized by this servicer were from a prior servicer, and there's not one reference to a boarding process, checking for accuracy, and complete derogation of Callaway and the body of case law that we have on boarding records.
And did you bring the motion to strike to the judge's attention at the hearing on the motion for summary judgment?
I wasn't permitted. I wasn't given
You
time.
try and were turned down, or you simply didn't try?
It never got to that point, and I'll tell you why. At the hearing, and the transcript's recorded, the transcript is part of the record, plaintiff argued a different angle that they had never pleaded before, which was that my client does not have standing to raise any defense, which is kind of where we're leading into. Because of that, the judge was hung up on that issue, would not hear other issues, requested a memorandum of law.
Would not
adjourned.
hear other issues. Did you ask to hear another issue and the judge said, I'm not going to hear it, or did it just not come up?
You will see in the transcript, and when counsel's up here, I'll look for it. But the court specifically said, hey, that you're right, but if I rule on their issue, then I don't have to get to yours. So I was cut off from arguing that. So, as far as that goes. Anyway, the affidavit should have been stricken. As I've led up to, this is a good segue into the point that I was going to make, is this court determined that my client was not entitled to raise a defense. This raises an issue that I think is important for this court to address, because a lot of trial courts are addressing.
Did the court say that? Or did the court just grant summary judgment, enter an amount?
The court requested memorandum, and then with no further argument or explanation, just did the form judgment.
So we don't know if the court accepted that argument or
Well,
not.
the issues were before the court. They were made part of my response in opposition to summary judgment. I listed summary judgment evidence. I listed those arguments, and the court did not want to hear any argument like that, requested memorandum on this point, on the point of whether my client had standing or not. And we never got to those issues. So I believe it's clear error, unless this court is going to say that.
But there's nothing,
judge is right.
there's nothing in the judge's order that indicates
No.
how the judge ruled on that particular issue.
No, and I'll just say this, my understanding is if there's a motion pending and the court doesn't adjudicate it, that's deemed denied. I don't know if that's correct or not, but that's just the way I've always proceeded, but I think that's correct. Anyway, what presents a novel issue for this court is there has been a lot of banter. There was fourth DCA just came out with a decision which I cited as supplemental authority. The first DCA in their Clay County case, which is cited in my brief, both say that a third party doesn't have the right to raise contract defenses, or at least that's what Clay County says. But they certainly can raise standing. And in fact, if you look at the Clay County case, they said you can't raise a contract defense, but it was a summary judgment that was overturned because the affidavit wasn't sufficient, and the court permitted and said, you do get to challenge standing. Said those two things, and you get to challenge damages. So that is the position that counsel argued at the hearing. And what happened was, without ever pleading this issue that we don't have standing, without ever raising it, even in their reply, without filing any motion, they sandbagged me at that hearing and said, oh, hey, these guys don't have a right to do it. And the judge entertained that issue despite it never being framed. And I believe that's incorrect. This court has ruled that if you want to avoid an affirmative defense pursuant to 1.10 of the Florida Rules of Civil Procedure, if you want to avoid an affirmative defense, you have to plead the avoidance.
Was standing argued at the summary judgment hearing?
Yes, that was the only thing that was argued, was do you have standing? I said, look, I've got case law, we can argue this. The judge said, I don't have a case before me, I don't have a case before me. And indeed, I didn't have a case because they didn't notice that issue. It was never before the court. So the court entertained an issue that was not pleaded, decided this case on an issue that was not pleaded. And according to this court's prior rulings, if you want to avoid an affirmative defense, and we did plead standing as an affirmative defense, and we pled conditions preceding, if you want to avoid an affirmative defense, you have to plead it, and they didn't do so. The only way we can think of is that this court, along with a line of cases that are starting to come out now, is that third parties don't have certain rights. Those are all cases that pertain to the HOA situation, where it's an inferior lien. In our situation, we have a bankruptcy trustee with an assignment. And I have never seen in Florida a case where a court negates an assignment of the right to defend an action. And that's what we have in this case. It clearly says, we're giving you, as part of the trustee's deed from the bankruptcy trustee, in the deed itself it says, and we're giving you and any assigned of you the right to defend this action, any defenses that the trustee has. That is a double issue. Number one, no Florida court has addressed the issue whether you can assign your right to defend a contract. In fact, the leading case on that is actually in the reverse. It's the Forgione case. It's a Florida Supreme Court case where an action was originally filed in the trial court of the federal courts in the Southern District. That court determined, hey, you can't assign contractual rights. It went to the 11th Circuit, and the 11th Circuit said, you know what? This is an issue of Florida law. Let's show us the courtesy of asking them, and that's the Forgione case. And the Forgione case says, we disagree with that. We think you can assign rights as long as they're not too personal in nature. That completely dovetails into the recent ruling of the 4th DCA where they said, hey, you do get to, you cannot transfer the right to contest the validity of the mortgage, meaning you can't argue duress, fraud in the inducement. You can't do that as an assignee because the remedy is rescission, which means you have to put the parties back in the position they were, and if it's not the same party, you can't do it. So the leading case on this, the 11th Circuit, respecting the Florida state courts, said, hey, Florida Supreme Court, what is the answer to this question? How do we resolve it? And the Florida Supreme Court did. This is a reverse situation. Prior to, or subsequent to this decision being handed out, the 11th Circuit in the Fela case, which is cited, said when a party surrenders in bankruptcy, they surrender to the trustee who can either sell their rights, liquidate them, or if they choose to abandon it, those rights go back to the creditor. But the debtor no longer has any rights in the property and cannot get in the way of a foreclosure. In this case, the trustee did not abandon it. There was a surrender to the trustee who liquidated it, sold it to a third party. And the question is, who gets to decide if that assignment is valid or not? It seems like the federal cases, and there's a case I cite, Larkin, where the federal courts get to decide whether the trustee has exceeded their bounds or not. But I would respectfully submit that this is akin to a foreign judgment coming in here, and this court should give it full faith and credit. There's something that was purchased in another state, and unless there's an overriding reason for it, we should give it full faith and credit in the bankruptcy situation and particularly where there's a specific assignment of this right. I'm going to stop there and leave myself whatever time is left, but thank you very much.
Got about 6
Unless there's
minutes.
questions.
Got about 6 minutes left.
All right, thank you, sir.
Good morning, Your Honors. Eric Levine of Ackerman LLP on behalf of Appellee Nation Star Mortgage LLC. May it please the Court. The issues raised by the appellant are generally immaterial and therefore don't require reversal, as none of them show an issue of fact that requires a trial, and therefore the final judgment of foreclosure should be affirmed. The first argument that counsel brought up was standing, but as this Court just said on October 27th in the U.S. Bank versus Glicken case, when the note with an undated blank endorsement has been attached to the original complaint, this is sufficient to prove standing, provided that the plaintiff produces the original note at trial or files it with the trial court with the same endorsement, and there are no subsequent contradictory endorsements, which is exactly what we have here. The note attached.
You argue below that the defense couldn't even bring up the defense of your standing?
I don't believe we argue they couldn't bring up contract defenses such as conditions precedent, but they're certainly allowed. I don't believe we ever said they couldn't raise standing to foreclose. I mean, or amounts due and owing. I believe the courts have said third-party purchasers can challenge standing, and because it affects their redemption rights, they can challenge amounts due and owing. But whether they can or can't challenge it is actually a moot kind of academic point because we proved it with evidence. And as the court noted, the trial judge never actually said they couldn't do it. He heard briefing on it, never issued a ruling. So that whole discussion as to whether they have standing to challenge the evidence is really immaterial because the evidence was there anyway to show that no issue of fact exists. So the issue of standing, I believe, is established.
Is there an issue of fact as to what the interest rate
No,
you're
Your
entitled to under your documents is?
No, Your Honor, and I'll explain why. I think Judge Evander kind of hit this. If you come into court with a contract, say I come into court with a contract and says, Judge, here's a contract that says I'm owed $10, but I'm okay if you award me $8. The judge is going to say, sorry, it's all or nothing. The judge will say, okay, I see you're entitled to 10, but if you're telling me you're going to stipulate to $8, I'll give you $8 because that's what the party entitled wants. And that's all we have here. The interest rate that we sought in the final judgment was less than the contract rate.
If you come into court with an attached contract that says you're entitled to $10, and you come into court and say, I'm seeking $8 because that's how much I'm entitled to under my operative contract with the other party, does that create an issue of fact because it differs from what the attachment says?
I would say that it doesn't create an issue. I would say it doesn't create a material issue of fact. To the extent it creates an issue of fact, it's not one warranting trial because any defect is purely beneficial to the defendant, in this case the appellant. Any error with awarding us less than what we were owed, to the extent there is an error, only helps him. Their redemption amount is lower. There's no need for a trial.
Is it relevant that the alleged monthly payment is greater than what the contract calls for?
No, the monthly payment was less than what the contract called for.
I thought the original contract said they had to pay $892 a month, and then you said your damages were based on a monthly payment of $907 a month. So you're actually saying they owed more than the contract says, even though the interest rate is lower. Is that not right?
Sorry, I believe the initial brief said that we were charging $675, not $900.
Okay.
So I believe that it was less interest and less monthly payment, in which case it's immaterial, since if we're asking for less than we're owed, then that's only hurts us. It doesn't hurt the appellant. And as for the issue,
Well, does it not, at summary judgment, does it potentially raise an issue whether or not there is another operative contract as opposed to your party is just gratuitously deciding to collect less interest?
if there was actually summary judgment evidence of that, perhaps, but in this case there is no summary judgment evidence, and the court asked, is there any evidence of a modification? And counsel said, well, I'm only venturing an educated guess.
They don't have to put in any evidence. You have to rebut any potential defenses, right?
And we have to overcome affirmative defenses, but we're not talking about an affirmative defense. We're talking about the amounts due and owing, which isn't really an affirmative defense. We're saying this is how much we're owed under the contract. We're seeking less than what the contract says. So the fact that we're asking for less
Well,
can't
we
be
don't know
material.
whether that's because there's another contract or because you're just feeling generous that day, right?
Well, maybe not, but that would be just speculation on the part of the defendant. He's coming in saying, well, Your Honor, maybe they're not just being generous. Maybe there's this other contract out there. Speculation doesn't get you around summary judgment. You need evidence. It was pending for 2 years, this case, before, I believe approximately 2 years before summary judgment. So all that time, no evidence of any other modification was ever brought to the court. So just guessing is not enough.
The fact that you're only asking for half the interest rate, is that not evidence from which an inference could be made that there's some modification, because there is no other logical reason for you to only be asking for half the interest?
Well, in this case,
unless you think it's reasonable for the court to conclude you're just being generous and giving up interest that you have a legal right to.
I believe that the court could take the position that if you're seeking less than what the contract says you're entitled to, whatever reason it might be, is immaterial.
Well, it's not immaterial if the reason is because there's a different contract that controls, correct?
If that were the case, potentially, but there would need to be evidence of that.
Well,
and there's
evidence
no
by you
speculation.
in support of your summary judgment. Maybe at trial that becomes an issue, but at summary judgment, isn't that enough?
I wouldn't say it would be enough to get around to defeat summary judgment, because look at the universe of evidence. The court gets to look at all the documents and all the evidence presented and can say, this is what the note says, this is what they're asking for, therefore, why do I need a trial when the plaintiff is telling me they're asking for less than what they're fully owed? Why do I need...
That's not what the plaintiff is saying. The plaintiff nowhere affirmatively said, I'm asking for less than I'm owed. What he's saying is, this is what I'm owed, right?
This is what I'm owed.
If
That's
he's
true.
saying, this is what I'm owed, that can only be an accurate statement if there's some other document in play, correct?
Well, I think it could still be, I think whether it's an accurate statement still goes back to whether or not it's a material issue, because...
Well, it's certainly material if they're saying that there is a different contract in effect than the one that they're suing on, right? That would, by definition, be material.
Yeah, that would be
right?
material, again, if there was evidence of it. And I think that's the whole problem with the appellant's case, is that they're coming and saying, look, there's this discrepancy between what they're asking for and what the note provides. We don't know really what the reason is.
Maybe that's why we have trials rather than summary judgment, because we don't know, and if we have a trial, maybe we can then figure it out, because it's unreasonable to assume that the reason is because the bank is just being generous and eating half of their interest that they're entitled to under the contract that they're suing on.
I suppose that if this had gone to trial, that could have come up, and then the court could have weighed the evidence and made an inference. I would still submit that why do we need to, if the result of a trial, let's say if the court were to reverse, or maybe summary judgment was denied and it went to trial, if the only result would be the same as summary judgment or more to the plaintiff. So there's no allegation that if we had gone to trial instead of summary judgment that our judgment would have been even less than what it was. It was only going to be the same or going to be more.
Or it could be that you're not entitled to a judgment at all because you've sued on a contract that's no longer in operation. That's another possibility if you went to trial,
but I believe
right?
but I think, again, that's just speculation as to what happened.
Okay, but your argument that they could only do worse if they went forward to trial is not accurate, because they could do better, because one possible result is you would lose because you sued on the wrong contract, right?
Well, I don't believe that the court, when reviewing a summary judgment, or when a trial court is ruling on a motion for summary judgment, entertains, well, what's the random possibilities that what could happen here?
You're the one who made the argument that if they went forward, the only thing that could happen is they could come out worse or the same.
Based on the evidence, well, we have this universe of summary judgment evidence here as to what happened. Based on this evidence, all we know is that either we got what we're owed or we got less than what we're owed.
Let me ask you this. Was there anything in the answer affirmative defense's pleading that there was a modification?
I don't believe so at all in the answer and affirmative defense is filed by the appellant, Your Honor. No.
Was there what do you recall what the pleading said as to your allegation that that this was the controlling note and mortgage? Was there an admission, a denial, or without knowledge, or?
I have to pull up the answer. I believe they deny. I mean, typically the answers are just simply denial, deny standing, deny conditions precedent. But I don't recall a specific denial. It does say admitted that the mortgage attached appears to be a copy, defendant was without knowledge of the allegations, admit that we're attempting to foreclose. They basically say without knowledge as to the note, but they admit that the mortgage appears to be the one that was recorded, and then we deny that we're the holder of the note. But I don't see, and then they affirmative defense of lack of standing and affirmative defense of failure of conditions precedent, set off. There's no affirmative defense specifically saying that there is a modification, or there's no affirmative defense that says there is this other contract out there. So to the extent that that could potentially be a waiver of that potential defense, then that would apply here. And as for the issue of the admissibility of the affidavit, I think the court properly realized that that issue was never argued to the trial judge. He never said to the trial judge, this is a hearsay affidavit, never brought his motion to strike to the court's attention. I read the hearing transcript several times to make sure I was making an accurate representation of the brief. The trial judge never said, I won't hear that argument. He never told counsel, stop talking, I'm not hearing anymore. The trial judge was willing to listen to whatever counsel said. He just never said, I have a motion to strike pending, or this is hearsay. So unless the court has any additional questions, we would ask that the court find that there are no material issues warranting reversal and affirm the final judgment of foreclosure.
Thank you, counsel.
Thank you.
Please, the court. Just to address some of those issues very quickly. First, with respect to the trial court, the transcript, I would direct everyone's attention to page 13 of the transcript, and it has been filed. I don't know how it's designated. I was a little more long-winded than I may have led the court to believe, and that's just my nature. But I said at the bottom of that, line 17, but I'd like to add this: the issue of whether they're suing on the right note or not has nothing to do with any of those cases. We're just talking about the cases. It's their burden to attach the correct mortgage that they're suing on, simultaneously speaking, and the court said, well, I agree with that, but if you don't have standing to put forth a defense, then I don't even need to consider it. So the court stated they're not considering that issue. As far as the cutoff goes, yes, on page 9, I went through the first issue with the mortgage, about the 625%, and then I said the next issue, and the court said, hold on. Mr. Scheer, what do you say about Mr. Mauser's claim? And that's when I was going to go on to the other issues. The court said, hold on, and wanted to stay focused on that one issue. That's why we never got to it. So when a court says, hold on, I will respect that. With respect to the affirmative defense that I asserted on standing, discovery had not been completed by the time when I filed my answer. The discovery process is where we got the record showing the difference in what they were attempting to enforce, and that's the first we learned of it. Again, my client's a third party, didn't have access to it, didn't know. But as far as standing goes, plaintiff's complaint fails to mention who is the owner of the note, and as such, plaintiff is, unless plaintiff is the owner of the note or has been authorized by the owner of the note, it's either the holder or someone who in possession with the rights of a holder, to prosecute the action, plaintiff cannot be deemed on its face to be holder in due course. Upon information and belief, as evidenced by NationStar's response to a qualified written request, which was at or near the time suit was filed, 2014, plaintiff asserted that servicing transfer notice will detail the date of the service transfer from the prior servicers, but going down, I want to get to the specific language in this. The letter does not state that it has done, clearly indicates the distinction between temporary possession. I'm sorry, it says that NationStar is in temporary possession and that they are the servicer, and we've attached to our answer copies of the notes in question. So as far as putting them on notice and springing that, no, we didn't. They're the ones who, in their reply, never said we lack standing, never raised the issue, and therefore should not have been permitted to raise it on a summary judgment. I feel that's a pretty strong point. Moving on to the next part, as far as whether a third party, what rights they have, Again, this is a first impression because I am not aware of a state case that says if you are given an assignment of these rights from anyone, even the borrower, even the debtor, if you're given an assignment of these rights, you don't get to raise those defenses. I'm not aware of a case. It could exist, but I've never seen it. But I know there is not a case that says when a federal court, a trustee, says, here, you get the deed, we're selling it to you, along with the rights to defend this. There is no case that, and again, research this and never found a case that says a state court gets to say that trustee went too far. They overstepped their bounds. We're not going to give this full faith and credit like we would someone domesticating another judgment. We're going to say, no, they don't get to raise it even though this says they get to raise it. We're not aware of that. And I'll just stop on that. I think it's important, as there are more cases out there pending. I'm kind of the guy who handles these when they go through the bankruptcy trustee. I know that there's several courts waiting for a decision on this and would be honored if you would address the issue. I think that's the best way to say it because things are a little topsy-turvy. The second DCA is saying third-party rights don't exist, and have gotten rulings there, even with bankruptcy issues. And the first DCA says everything but contract defenses. The fourth DCA seems to leave open that contract defenses could be assigned. So I ask you to consider those points, and thank you for your time.
Thank you, counsel. Court being recessed.